So welcome everyone to this webinar in which we're going to try and bring some of our content from our regular newsletter, Private Affairs, to life. This is the first time we've done this webinar, so do bear with us. First of all, to introduce myself, I'm Chris Belcher. I'm a partner in the private client team here at Mills Reeve, and I'm joined on the panel today by Smyth, David Catchpole, and Sarah Nurik, who are going to provide a little bit of insight into some of their articles from our Private Affairs newsletter. So to begin, just some housekeeping. First of all, this webinar is being recorded. When we've finished, you'll get an email with a link to the recording. You'll also get a copy of the couple of slides we're going to use today. When the webinar has finished, there will be a feedback form pop up on your screen. So if you could complete that straight away, that would be great. It's only a short webinar, but we will try to take some questions as we go along, if there's time. Please just put those questions in the Q&A section. If you hover at the bottom of the screen, you'll see that. Those questions will be anonymous, and we will try to take them if we can. If we haven't got time, we'll try and follow up with you individually afterwards. So what I'd like to do first of all is to introduce Neil, who is going to talk to us about the mitigation of risk for our private clients. Neil, over to you.
Thank you very much, Chris. Good morning, everyone. As Chris has said, my name is Neil Smyth. I'm a partner and I'm National Head of Restructuring at Mills Reeve. And you might be asking yourself, well, why am I hearing this morning from a restructuring partner in relation to a private client presentation, which is really the point of what I'm going to talk about, which is the risk mitigation product that we have launched for clients. If you have the next slide. So what we've been looking at is, particularly in these current times, the services that we can provide to our high net worth individual clients, above and beyond those services that you are probably used to hearing from us about. So hopefully you know all about the strength and depth of Mills Reeve's expertise in relation to wealth planning through its private client fee earners regarding wills, trusts, etc. But you may know less about how we can actually help mitigate risk for our high net worth individual clients in various different areas as well. And this is what the website, which I will show you in a bit, deals with, really split down into different categories, as well as wealth planning. It details the expertise that we have through our family team in relation to divorce, pre-post nuptial agreements, child arrangements, etc. So from that perspective, to the extent that there is risk to personal affairs, that may be in relation to the high net worth individual themselves. It may well be in relation to family members. If they are marrying, if people are marrying into the family, how will that interact with the wealth planning that is already in place or is intended to be in place regarding succession and inheritance? Does there need to be any control around the flow of wealth, to the extent that, unfortunately, marriages do not work out, people get divorced, and also risk and disruption to family life to the extent that there are children involved, custody issues to be resolved. So that's where our family team can help in relation to risk. We also, slightly more outside the private client family teams, have brought together details of our expertise in other less associated areas. One of those is reputation management. So dealing with issues as set out like defamation, image, reputation protection, and risk to privacy. Now, this goes both to family affairs and it also goes to business affairs. To the extent that something defamatory is posted, most probably now, on social media, then how would you, your family, your business react to that to ensure that you are protected? And particularly at the moment, we are seeing posts being put up, people's reputations very quickly disintegrating over various different issues. And so this issue has become much more important in making sure that your interests, your business interests, are protected as much as possible. And if someone does defame you, post something on social media that is untrue, you need protection and you need it quickly. And we have a team that can assist with that, who are available on a 24/7 basis to ensure that if something is put on a social media site, more likely now than put in writing or published, that it is taken down, an apology issued if it's untrue as quickly as possible, injunctions are sought, because that very much ties into family affairs, protection of wealth, and also business affairs. And you will have seen in the press how quickly poor publicity can affect businesses and can have an effect on wealth creation. Linked to that, what we are seeing increasingly is cybercrime. So whether that be in relation to actual threats, blackmail, whether that be in relation to the holding of data, to the extent that we've seen various actions brought against large organisations like British Airways over the last few years, where data has leaked out, and how that can again pose a threat to both personal and business wealth, whether that is targeted or possibly by way of mistake. And again, we have a team who have expertise in dealing with these issues, to try and ensure that we can provide as much protection and risk mitigation to your family and business affairs, to the extent that you are being targeted by cyber criminals, and or there are issues around data protection leaks that have a knock-on effect to the personal and business wealth side of your affairs. And finally, my area of expertise, restructuring. Now you may say, well, I am, what does restructuring, what does insolvency have to do with what I do? Well, in these economic times, it is probably more likely that we are actually talking about those that you interact with. At present, economically, there is a large amount of government assistance to businesses, which will fall away during the course of the summer. And we do anticipate there being an increase in insolvency processes and business failures. So the question for you in relation to your business affairs is, to the extent that you are contracting with other counterparties, what do you know about their financial affairs? And to the extent that they were to get into financial difficulty, what would you be able to do about that? How would you be protected? To the extent that the average return on an insolvency process, particularly administration, is normally between 1% and 3%, and is often nothing if you are an unsecured creditor. So you can find that the failure of the counterparty can have an exponential knock-on effect to your own business affairs. And therefore, we are advising a number of clients at the moment to take more proactive approach to their counterparties, to make sure that they are protected, and ideally improve their position from simply an unsecured creditor, to the extent that those counterparties get into financial difficulty. But from your family side, to the extent that there is a family member in financial difficulty, how that might knock on to your family and business affairs, to the extent that money has been lent to other parties and needs to be reclaimed, is that properly documented? How would you actually going about recovering that? And sometimes there are simply just breakdowns in the system. So I've previously acted for a high net worth individual who didn't open her own post for various different reasons, and therefore missed the fact that she had a fairly large tax bill, well, a large tax bill by anyone else's stretch of imagination. She also didn't realise that HMRC had then served a statute of demand on her, presented a bankruptcy petition, and then obtained a bankruptcy order. The first letter that she opened was from the official receiver, requiring her to come and give information about her affairs. So we helped her because the tax bill was about £200,000. She had £1 million worth of cash just sitting in a bank account, and therefore was easily able to pay the debt. It's just that for whatever reason it had not got paid, and therefore we assisted her in actually applying to be annulled out of bankruptcy, as if the bankruptcy order had never been made, because of the consequences the bankruptcy order had on her affairs and her reputation. So there is a link through all of these elements that if you are subject to a cybercrime, that may cause insolvency risks upon your business. If you are contracting with a party gets into financial difficulty and looks to put leverage on you for repayment, then they may be posting things on social media to try and increase the pressure, which may fall under reputation management. So all of these areas are linked, and it may well be that in mitigating risk in relation to your family and business affairs, that you would be looking to call on more than one of the teams that I've just described. But on the next slide, we will just quickly show you the web page. So, as I say, what we've done is we've pulled together expertise in one place so that our clients can see those various different areas that I've described from a risk mitigation point of view. So if we go into the website, I'll just quickly take you around that. So if we just click onto one of the sections, so there we've got some information as to what the services we can provide in relation to defamation and a partner contact, and that is the same for all of the different sections on the website. So all in one place, to the extent that you may need some assistance around various risks to your own family and business affairs. You have the information, you have the contact details, you have details of experience that we've had acting for high net worth individuals in these various different areas. So that's a very brief run through of the product and the website. So I'll pass back to Chris just in case anyone has any questions on any of that.
Thanks, Neil. Really interesting and great to see the different services that we can provide, but also to think about the different areas of risk for our clients. I've had one question just deal with briefly, and this really touches on your area personally, Neil. Someone is saying my personal and business affairs haven't been affected by the pandemic. Why would I need a restructuring lawyer?
Indeed. Well, I think, and that is good to hear from your personal point of view. But as I say, I think most of the risk that we are advising clients on at the moment is not in relation to their own business or family restructuring needs or insolvency needs. It's in relation to the people that they contract with, whether that be within their families regarding lending money to third parties or helping out businesses and then trying to get that money back, through to having that very important contract for supply from an entity possibly based in the UK, possibly based internationally, that is absolutely crucial to the business, and working out what would happen to the extent that that entity enters into some kind of insolvency process or gets into financial difficulty, and where that would leave, both in relation to sourcing alternative supply, but also recovering any money due, and just being proactive around the situation rather than reactively waiting for it to happen and then getting into a tailspin as to exactly how you would sort that issue out.
Thank you. That's great. Well, thanks very much, Neil. I'd like to hand over now to David Catchpole. David's going to talk to us about Proprietary Estoppel.
Thanks, Chris. Yes, hi, I'm David Catchpole, a partner in the Estates, Trusts and Will Disputes team at Mills Reeve. So Proprietary Estoppel, well, most people know that when they're producing a will, there are strict statutory requirements that they have to follow. They know that they have to sign something, and they know that there have to be a couple of witnesses there to witness them signing. And those strict requirements are there for a reason, because your will is one of the most important documents that you will execute when you're alive, because it gives away your estate on your death, your whole estate. And so you can understand why those restrictions are there. Proprietary Estoppel, though, can give away almost all you own, or all you own, or the most important asset that you own, but there are no requirements for it to be in writing. There are no requirements for it to be witnessed. Some people don't even appreciate that they are potentially giving away something during their lifetime. So let's have a look at proprietary estoppel. A brief run through in 5 or 10 minutes. What does it mean? Most people have heard of proprietary estoppel, but aren't really sure of the details. So proprietary estoppel, it's an equitable thing. There is no statute which covers proprietary estoppel. It's built up in the courts of equity over several hundred years through a series of different cases. And equity deals with fairness effectively. It says equity will step in and provide a remedy to someone if there has been something that was unconscionable or inequitable. So proprietary estoppel is where someone has made a promise to someone, that person has then relied on that promise to their detriment, and then the person who has made the promise reneges on it. So the court will step in those circumstances and say that's not fair, it's inequitable, and we'll provide a remedy in certain circumstances. So there are 3 elements there, as you can see. There has to be a promise, an assurance. There has to be reliance on that promise by a person who is seeking to rely on the promise and to provide them with a remedy of estoppel. And there has to be a detriment. So that person has to act to their detriment in reliance on the promise that they've received. And those are the 3 elements that you have to prove in an estoppel claim. So the assurance itself has to be clear enough in context, is what the courts have said. So it's usually verbal. It's very, very seldom is it written down anywhere. So that's an evidential difficulty. It's verbal. It can be something that was said many, many years ago. And often it's something that's said and is then repeated over a number of years. So that the typical case is, one day all of this will be yours, from a father to a son in a business or a farm. So there you have that assurance. That's the starting point. You then have the reliance on that promise. So the person has to rely on that promise. They have to change their course of acting. So, for example, if a farmer promises his son, one day all of this will be yours in relation to a farm, the son then, in reliance on that promise, doesn't take up any other alternative employment and works on the farm. And then the third element is this detriment. So there has to be detrimental reliance. So that detriment is usually something financial, but it's not necessarily financial. It can be giving up other opportunities in life. And in the situation I've outlined there with the farming family, the detriment often is working for very little pay or no pay, long hours, and not taking up other opportunities. So if all of those elements are met, then the court will say, well, it's unconscionable for the farmer in this case to leave his estate to the cat's home, for example, when the son has worked there all his life. And in those circumstances, the court will step in and say, that's not fair, that's inequitable, we will provide a remedy. And there's a lot of controversy in the cases at the moment as to what that remedy should be. Should it be they're given what they're promised? What happens if they haven't actually suffered that much detriment? So if they've worked on the farm all their life, but for a reasonable amount of pay, should they be awarded the whole farm that could be worth millions of pounds? So there's a difficulty there about what that remedy should be. The courts generally say it's the minimum to remedy the injustice, but that's a fairly wide concept. And I think it's quite useful in this case to this doctrine, this sphere, to look at some of the cases. The vast majority of cases are farming cases. Farmland is obviously a valuable asset, and there's a lot at stake. And when there's a lot at stake, people tend to want to argue over it. And also farmers typically don't write much down. They have lots of conversations over the sort of farmhouse table. Promises are made to various family members and then sometimes are not kept. And a good example of that is the case that came out last year, just before lockdown in March 2020, case of Horsford and Horsford, a rather sad case, but it's not untypical of the sort of cases that we see. And in that case, we had a married couple, Marianne and Davis Horsford, married in 1954, had built up a farm together just outside Cambridge, about 540 acres. By the time it came before the court, the farm was worth about £6 million. And they had 3 children, 2 daughters and a son. And not uncommonly, again, in farming families, the son was the one who worked on the farm. The daughters had nothing to do with it. So Peter, the son, worked on the farm for a number of years, and he didn't have other employment. He went off to agricultural college to learn his trade, and everything seemed to be working well within the family. He became a partner in the business, so he had a share of the business. And then things went wrong in 2011. So by that stage, Marianne and Davis had been married for 57 years, but they separated. It's not clear from the judgment. We weren't involved in the case, so I don't know. I don't know what the reason was for that separation. But but they weren't young at the time. They'd been married 57 years. They separated, and as a result of that, the three partners, the three family members, decided to put their partnership on a more formal setting and executed a formal partnership agreement, and that set out the rights of the parties. And then a few years later, in 2016, Marianne, by this time, was becoming quite elderly, didn't want to work on the farm anymore, and she served notice of retirement on her husband, or separated husband, estranged husband, and her son Peter. And Peter said that he wanted to acquire her share in the business, which he was entitled to do under the partnership agreement, and he carried on farming. But what he didn't do was pay Marianne for his share in the business. He should have paid her, she said, £2.5 million to acquire her share. He refused to pay her. She sued him. Happy families. At the time she sued him, she was 88 years old. And he responded to that claim by saying, I don't owe you anything. I was always promised this farm. I've got a proprietary estoppel. I don't owe you a penny. And the matter went all the way to the court. And the court made a decision, as I say, just before lockdown last year. Unfortunately, the father, Davis, by this time had got dementia and was in a care home and couldn't provide any evidence. And unfortunately for Peter, he lost. The court found that there wasn't an estoppel. They said that the comments which had been made over the years by the parents to the son were not as strong as assurances. They were not promises. They were just a statement of intention, what they thought they might do with the farm in due course. And they said that although he had worked on the farm, he'd got paid. Peter had been paid a reasonable salary and had lived on the farm and therefore had suffered no detriment, with the outcome being that he owed his mother £2.5 million, which he's going to have to try and secure on the farm because that's his livelihood. Or he may be able to sell part of the farm potentially. That hasn't, obviously, it's a fairly recent judgment. He hasn't decided what he's going to do yet. So not only has he got the £2.5 million to pay to his mother, he's got also the substantial legal costs of going through the High Court, which I suspect will be several £100,000 on top of that. So not a nice position for Peter to be in. So what can we take from this? I think, well, be careful what you say is what you should think about for yourselves and your clients. This doesn't just apply to farms and farming families, although, as I say, the vast majority of cases are farming cases. Be careful what you say, write things down so that you've got a record, and if at all possible, try to avoid litigation, because litigation in these types of cases can be very lengthy and very expensive. Okay, Chris, thank you.
Thanks, David. Yes, a salutary warning there. We have had a couple of questions which have come in. We haven't got a lot of time, so just very quickly on one of them. Someone's asked us, don't transactions in land have to be in writing?
Ordinarily, yes, they do, but proprietary estoppel sidesteps that. Another one of those weird things that I think is strange, like I think, the requirements for a will are so strict, and yet proprietary estoppel is sort of vague, is that you don't have to have, there's nothing needed in writing. A promise which is relied on to someone's detriment, even though it involves land, as this case did in the farm, doesn't need to be in writing.
Thanks very much. So just briefly, before I introduce our final panelist, I just wanted to comment on something which a lot of you will have heard us talk about over the last few months, and that was the budget. We expected, as did many people, that there were going to be some quite drastic tax changes to the private client taxes, inheritance tax, capital gains tax, in the budget in early March. And happily, we didn't see any of the changes which had been rumoured. But what we did get from the Chancellor was a slightly odd comment that he was going to publish a series of consultations on the 23rd of March. And so rumour mill again went into overdrive to suggest that although those tax changes that we had feared weren't going to be there in the budget, that they might come in by the side door, as it were, with these consultations. So 23rd March has now passed. We've seen the consultations which have been published, and again, some good news really, that there is nothing in there to cause our clients any particular concern about changes to tax, inheritance tax or capital gains tax. In fact, there is a consultation which is designed to take more people outside the reporting requirements for inheritance tax, which is good news. And the only other really interesting consultation, I suppose, is around a government response, which we're now expecting to the 2018 review of the taxation of trusts. So it is still a bit of a case of watch this space. I think we are all expecting at some point there will be some tax rises to pay for the public spending, which has been necessary over the last year and more as a result of the pandemic. But for now, our concerns about the changes to the business property, agricultural property reliefs, and other areas of inheritance and capital gains tax are on the back burner. So some good news by way of update. So finally, I'd like to introduce Sarah Nurik, who is just going to comment on an exciting research project which we're kicking off here at Mills Reeve. Sarah, over to you.
Yes, so over the past year, we've obviously been helping clients through a huge period of change. And one of the things they've been telling us is that they've really valued the peer-to-peer support that we've been able to provide. So the Building Resilience campaign is really brings these elements together. So it's a mixture of horizon scanning. We're looking at risks and challenges and opportunities that are coming in a number of areas. And we look at three in particular, and they are supply chain management, ethics and sustainability. We're seeing a huge amount of private clients at the moment looking for more ethical investing, and also workforce issues. And it's really about sharing best practice. So we've got a number of case studies looking at how clients have dealt with some of these big issues. So in the Private Affairs magazine, you've probably seen an article from Adnams looking at how they've approached the issue of sustainability in their manufacturing processes. And we've got a number of other articles on similar topics. We have done some research. We've done a YouGov survey, and that's revealed some really interesting information to us, which we'll be looking at in more detail. One of the points is around data. So we've got a lot of companies telling us that they want to make more intelligent, data-driven decisions going forwards, but they're also telling us that they don't know how to use the data that they've got. So we'll be looking at how you can approach that issue, how some other companies have, and some of our clients have dealt with this issue themselves, and the things that they've managed to do with their data to kind of improve their decision-making process. Finally, we've got some really great tips and information from our lawyers on there. So for example, if you're a business owner and you employ staff, we've got a great video interview with Andrew Secker, one of our employment partners, who really looks at kind of the return to work and what a hybrid half in the office, half at home model might look like, what the challenges in terms of risks and cultural issues that you may need to factor in, what things you might need to consider if you're looking at kind of workplace testing or tracking vaccinations. So all big issues and very topical at the moment, and some great tips about what you can do about planning for those. So there's a huge amount of information. We've got a hub, a website with everything on, which we will be sending out to you as in the thank you after this email, after this session.
Thanks very much, Sarah. I'm sorry you got the very short slot at the end, but we've reached our allotted time. We're at 10:30, so. I just wanted to say thank you to the contributors to this webinar. Much appreciate you giving up your time, and thank you to everyone who has watched the webinar. I hope you found it interesting. Any questions which we haven't been able to handle during the session, we'll try and follow up with you afterwards. I would just ask you as well, please do keep an eye out for our next webinar, which is planned for the 5th of May 2021. And booking details for that should be in the email which you will get by way of follow-up to this one. So thank you again for watching, and we look forward to seeing you again soon.